Well, I'm joined now by John Lesch, a criminal defence lawyer. Welcome to you. Thanks very much for being with us. So what do you make of that decision by Derek Chauvin and also of the judges to tell the jury not to read anything into it?
Thank you for having me, Samantha. This is a really difficult decision for any defense attorney. In the 15 years that I prosecuted, I did not see a lot of defense attorneys offering their clients up to be cross-examined by me. And as a defense attorney, I am loath, as any defense attorney is too. But it was difficult. Many of us were questioning in our minds as we approached that moment at the end of the defense's case as to whether or not Derek Chauvin would testify. Some of us, not knowing the case nearly as well as Eric Nelson, his attorney, were wondering if it wasn't the right time or not, because you need to give the jury an alternative narrative to decide whether or not they have reasonable doubt in any of these elements. And you're taking a risk in doing that or not doing that. Eric Nelson decided, nope, I'm going with the standby. Don't put him up for criticism or cross-examination. And that's where I sit.
You talk about reasonable doubt. What does the prosecution order the defence need to do to achieve for them to win this case?
So remember, there are 3 charges. And in each of those 3 charges, the state needs to prove each element of each of those charges beyond a reasonable doubt. So take, for example, the first charge, which is second-degree unintentional murder. And unintentional is essentially, in the United States, we call here felony murder, meaning you commit a felony and there should have been perhaps a death that was foreseeable based on committing that felony. Now, in Minnesota, we have a unique understanding of this because it can be part of the same act. It's not like you rob a bank and somebody could have died in the ensuing car chase. In Minnesota, it can be the exact same act. And in this case, it's third-degree assault. And the reason it's third-degree assault is because you cause substantial bodily harm. It's predicated only on the amount of harm, which in this case was a death. So all they need to show then is that Derek Chauvin committed an act with intent to cause fear or intentionally inflicted or attempted to inflict bodily harm. So if the juror decides that kneeling on that neck, if they decide that that was an intent to cause harm instead of an intent to detain, then they've met the elements. If the defense attorney can cause reasonable doubt about the reasons for that, maybe not.